Good evening, respectful ladies and gentlemen. I'm honored and privileged to moderate this seminar on the civil law effect on the FIDIC 2017 Red Book, which is provided by the Chartered Institute of Arbitrators, CIARB Egypt branch. We are privileged to have very distinguished speakers in this seminar, so I believe it's going to be very interesting. I would like first to introduce our eminent speakers. I believe most of you know Dr. Ahmed Waly, so I'll be very brief in my introduction. Dr. Waly is the managing partner of Waly Arbitration and Contract Administration firm. He's associate professor at Faculty of Engineering, Helwan University. Dr. Waly is a FIDIC interim accredited trainer. He holds a diploma in international commercial arbitration from CIARB London. He's a committee member of CIARB Egypt branch. Dr. Waly is a member of the CIARB, the International Court of Arbitration, Arab Arbitration Group, ICC, and the International Council of Commercial Arbitration, ICCA.
Thank you, Dr. Salwa, for the presentation.
Thank you. Then we have Dr. Walid Nimr. I believe he's also very well known to most of you. Dr. Nimr is the Contracts Director of Hill International Africa. He earned his PhD degree from the University of Salford, England. He completed his bachelor's and master's degrees in construction engineering from the American University in Cairo, as well as a master's degree in law with specialization in construction law and arbitration from Robert Gordon University, Scotland. Dr. Nimr is also adjunct assistant professor at the American University in Cairo. He's the Vice President and Education and Training Officer of CIARB Egypt branch. He is the President of AACE International Greater Cairo section. Dr. Nimr has more than 20 years of experience in construction contracts and claims management. Welcome, Dr. Nimr.
Thank you, Dr. Salwa.
Last, I would like to introduce myself. I'm Salwa Fawzy. I'll be moderating this webinar. I'm the Commercial Director, Contracts and Procurement at the Sweden Industrial Development. I earned my PhD doctoral degree in law from Université Paris Dauphine, Paris. I hold a master's degree in construction law and arbitration, LLM, from Robert Gordon University, UK, and Bachelor of Science degree in construction engineering from the American University in Cairo. I'm a fellow of Chartered Institute of Arbitrators and committee member of CIARB Egypt branch. And I'm author of the book, Practicing FIDIC in Civil Law Jurisdictions, Application of Time and Additional Payment Provisions. Before we start, I would like to introduce our new mentoring program established by the Egypt branch of the CIARB as the first program initiated by CIARB branch in the region. The mentoring program provides young CIARB members interested in arbitration and ADR with the opportunity to learn from the experience of more senior members of CIARB's community. The mentoring groups are formed of mentees assigned to a mentor, a senior arbitrator or ADR expert, and a mentor supporter, an established practitioner. The mentor and mentor supporter will be available to provide the mentees with career guidance and arbitration, ADR practical knowledge. Each group works together for a one-year cycle. The potential activities in the program include workshops, video conferences, publishing articles, sharing information, and networking opportunities. For more information about the mentoring program, please follow CIARB Egypt branch on LinkedIn, where the details of the program will be announced. You will find a link to this page on the chat box in this webinar. Regarding today's webinar, we intend to have panel discussions with our speakers, followed by discussions and questions. I ask you please to post any questions to the Q&A section, not in the chat box. We will take questions from the Q&A section and will not be able to take questions from the comments on the Q&A or from the chatting box. We expect to have quite a large number of questions, so we might not be able to answer them all. So we open the voting in the Q&A section where you can upvote the questions you wish to receive answers thereto, and the questions with the largest number of votes will appear at the top. Now, regarding our topic, although the FIDIC forms of contracts are devised for use anywhere in the world, the FIDIC is originally based on legal concepts rooted in the common law system. The second edition of the FIDIC suite of contracts, issued in December 2017, witnessed substantial changes and expansions from the first edition of the 1999. It is suggested that one of the factors affecting these substantial changes is the influence of the civil law jurisdictions on the FIDIC contract, which was initially drafted in a common law setting, as we just mentioned. Here in this webinar, we investigate this theory with references to the Egyptian civil law. Now we're going to have panel discussions with our speakers, followed by discussions and questions. In this webinar, we will have a number of poll questions, which we encourage you all to answer throughout the webinar. You can post your answers on the poll section. I will start with the first question. Are you familiar with the FIDIC 2017 Suite Edition? Okay, we'll stop the poll. Okay. It seems that 50% of the audience are familiar with the FIDIC 2017 Suite Edition and 50% are not familiar with it. Okay. We move to the second poll question. The second poll question. Did you use any of the FIDIC 2017 contracts in any projects? Could you please post to the poll? Okay, now we will end the poll. It seems that the majority haven't worked yet with the FIDIC 2017 contracts in any projects. Okay. Okay, now I would like to ask Dr. Ahmed Waly, do you agree with me that FIDIC 2017 conditions are now giving more consideration to the applicable law of the contract in general?
Yes, Dr. Salwa, I definitely agree with you. This is actually manifested in various conditions of contract where the FIDIC has explicitly and expressly added the consideration to the local law and embedded it in its articles. In fact, in addition to the four main principles that we are going to cover in this webinar, which are the good faith, the force majeure and exceptional event, the decennial liability and termination of clause, you can find, I'm posting here sample clauses where you will find that the FIDIC has in fact added or considered the local laws in its drafting. For example, in subclause 11.10, the unfulfilled obligation, although this will be discussed in further detail by my colleague, Dr. Walid. However, this subclause is discussing the ability or the entitlement of the expiry of the defects notification period in 2 years. It can be extended. It cannot be extended unless if it is prohibited by law. So I think Dr. Walid will discuss that in more details in few minutes. Another sample is clause number 11.11, clearance of site. This same clause was in 1999, which gives the employer the right to sell any of the contractor's equipment and surplus materials and so on if the contractor does not clear the site at the end of the performance after receiving the performance certificate. However, in 2017, the FIDIC has added that the employer has the right to sell to the extent permitted by applicable laws. I'm not talking here about civil law or common law. I'm talking in general that the FIDIC is considering the applicable laws in its 2017 edition. A third example that I'm going to present now is the termination of contractors for default. Again, this same clause with the exact wording was in 1999. However, in 2017, the drafters has added the words between brackets to the extent permitted by applicable law. So now the contractor, if the contractor failed to pay, to make a payment due to the employer, these the items, again, the contractor plants and equipment and so on, may be sold by the employer in order to recover this payment, however, to the extent permitted by applicable law. Another example will be the one regarding insurance, clause 19, and specifically 19.2.6. In this subclause, the contractor shall provide all other insurances required by the law of the country. So in addition to any requirement or any insurance requirement in the contract, the contractor has a duty to provide all insurances required by the law of the countries. Another, the last two examples will be regarding the dispute avoidance and adjudication board clause. In 21.4.1, in reference of a dispute to the DAB, the reference of a dispute to the DAB under this clause shall be deemed to interrupt the running of any applicable statute of limitation or prescription period unless prohibited by law. So this has to do definitely with, as you know, in the Egyptian law, the mudad al-taqadum and so on. So this is also covered in the 2017 edition. And the last example that I'm going to cover will be also in the dispute avoidance and adjudication board clause. This is in 21.7. In case of failure to comply with the DAB's decision, the arbitral tribunal shall have the power by way of summary or other expedited procedure to order, whether by an interim or provisional measure or an award, as may be appropriate under applicable law, the enforcement of that decision. So this is another consideration of the applicable law embedded in the FIDIC 2017 edition. Definitely, these are just samples that I wanted to present at the beginning of the webinar. If we are going to discuss these clauses in detail, we will need maybe 2 more webinars. So we selected to focus on 4 main principles as we said. As we said, the good faith, the force majeure, the senior liability, and the termination of contract.
Thank you, Dr. Waly. Seems very interesting. The principle of good faith is key in most civil law jurisdictions. Dr. Waly, are there any considerations of good faith in the 2017 edition which were not in the 1999 edition?
Thank you, Dr. Salwa. The brief answer to your question is yes, definitely. In my opinion, there's a very strong good faith influence, if you will, on this 2017 contract. And of course, any discussion on good faith and the Egyptian Civil Code, we have to start with the main reference of good faith in the Egyptian Civil Code, which is Article 148, as shown here on the screen. And it's comprised of 2 sentences. The first one just says that the contract must be performed in accordance with its contents and in compliance with the requirements of good faith. Notice here the word must, so it's an obligation. يجب تنفيذ العقد وفقا للgood faith. So with two things, the content of the contract and good faith. Now, the second paragraph, as if the first one is not vague enough, the issue of good faith, adds other components other than good faith. So the contract words in themselves are not sufficient, but there are other considerations that run alongside these words, which are al-qanun wal-urf wal-adala, law, usage, and equity. So this is in addition to good faith. So of course, as we may, of course, anyone who reads this will think, what exactly does good faith mean? What exactly does equity mean when we're like administering a construction contract, for example? How does that affect the clear provisions of the contract, right? So I'm sure these questions, of course, also come to the mind of anyone who's operating under a common law jurisdiction, for example, because I'm sure a lot of common law practitioners would say this concept of good faith is nebulous, it's vague, it adds uncertainty to the contract. So to help us understand this concept, if we can think of examples. So for example, signs of good faith dealing, what are they? One sign is, for example, of course, in the context of a construction contract, is say if an employer issues an instruction for an additional work, for example, and the contractor is late in providing a notice that this additional work will result in additional payment or time, but it's known that the nature of this additional work will definitely cost any additional cost and may have a time impact. In that case, it's an act of good faith that the employer will forego this notice requirement from the contractor, because it's well known that this instruction which the employer made or made the engineer do has this additional cost. The other example is, for example, if an employer, there's an additional time and cost that is due to a certain instruction that is given by an engineer, for example, and the contractor knows that, but instead of waiting for some time, the right time to, for example, raise this question where the employer cannot take any action, the contractor would be proactive and would actually ask the question as soon as the contractor discovers this that this instruction will result in additional time or money, just in good faith to save the employer from the burden of incurring unnecessary additional cost or time. Another proactive role by a contractor, which is also a sign of good faith, is if there's an error in the documents, there's a design problem, there is some kind of an ambiguity, as soon as the contractor discovers this ambiguity, the contractor would immediately alert the employer, alert the engineer, so that the adverse impacts of such ambiguity are recovered. Because as you know, when we solve problems as soon as they occur, then we can actually save on potential costs or time. Another sign of good faith, which I believe is extremely rare in the industry as a whole, is say if the contractor submits an application for payment and there's an error in this payment, which should result in additional payment to the contractor. So the contractor underestimated something, he made a wrong application in a formula, for example, or something that would give that contractor additional payment. The engineer, if the engineer discovers this error, the engineer should alert the contractor and should take that into account in the payment certificate so that this additional payment is made. That's a sign of good faith. Finally, if the employer has prior knowledge, or the engineer has prior knowledge of something that can give rise to a claim to the contractor from, for example, minutes of meeting or verbal discussion, but then the contractor just failed to submit the notice on time, then it's a sign of good faith that we will forego this notice requirement, because the employer and the engineer had prior knowledge. So the whole purpose of the notice is to have this knowledge. So if the knowledge was there in the first place, then we should not hang on to this notice requirement, for example. So these are just non-exhaustive examples. We can go on and on of signs of good faith, but of course, this is just to help us comprehend what does the law mean by good faith and equity and usage and all this stuff. So if we zoom in on these two, the contractor promptly notifies the employer of the potential additional time and cost for an instruction or because of an error in the documents. The contractor is here playing a proactive role. We can easily reverse this as well, so that the engineer and the employer are proactively giving the contractor a heads up that, you know, I am going to do this in the near future, which may result in additional resources to you, may additional cost to you, be prepared. So that is normally in construction contracts, and I think in the UK in several standard templates, it's called the early warning. And in the FIDIC 2017 edition, we have this new clause, 8.4, advance warning. So this is very, very important in my opinion, and it's clearly a reflection of good faith into the contract, because if you look at the opening statement, it says each party shall advise the other and the engineer shall advise the parties. Now notice the word shall. It's not an obligation, it's not an option, it's not an option, it's an obligation. Both an obligation, and not just on the employer or the contractor, on the three parties, the employer, contractor, and the engineer, that they must alert each other in advance of any known or probable future events or circumstances which may, and you have all these 4 items, notably of which is increasing the contract price or the time. So it's not really an option anymore. This is, in my opinion, it's a good faith. It's an example of good faith, but it is a contractual obligation now. The other big example, of course, we can't discuss time bars and civil law without going to, we can't discuss the FIDIC and the civil law without going to time bars. And as most practitioners, if most of the people are here in this webinar, if you have used the FIDIC 99, then you have most definitely come across this very famous, or shall I say infamous, and specifically this paragraph about the if the contractor fails to submit a notice within 28 days, then the contractor is deemed to have waived his right for additional time or money. So we're all familiar with this clause. So what happened in 2017? So in 2017, in the claims procedures, we don't have 1 time bar, we have 2 time bars actually. So let's look at them. The first one is now clause 20.1 in 2017 is now 20.2.1, this notice of claim here. And you will notice the first thing is that there's no longer the contractor and the employer. Now it's the claiming party and the other party. So it's now the clause applies equally to both parties, and the time bar applies equally to both parties. And the time bar that we have seen in 20.1 and 99 is in this paragraph right here shown on the screen. And basically it applies the time bar equally on the claiming party if that party does not fulfill the 28-day requirement in the contract. But then, so this is time bar number 1, if we call that. Then if we go to time bar number 2, there's, as we all know, that the notice is followed by the detailed particulars, right? So in the FIDIC 2017, we have the term fully detailed claim. So that fully detailed claim has the detailed particulars. Within these detailed particulars, we have a time limit for the submission of these detailed particulars, as you can see here on the screen from clause 20.2.4, 84 days to submit these this fully detailed claim. So what happens if a party does not submit within these 84 days? You can see here that from the red text is that if this happens, then the statement under subparagraph B, which I'm going to explain now, then in that case, then the notice shall be no longer, shall not be considered valid. So if the whoever the claiming party does not submit this subparagraph B requirement, which is basically the statement of a contractual and other legal basis of the claim. So as we all know, as part of the claim, there must be the legal basis or the contractual basis of the claim. So if the claiming party, for example, does not submit that, so there is you don't know what's the contractual or legal basis of the claim, and the 84 period has lapsed, in that case, and at the same time, that party had submitted the notice on time. So in that case, that notice that was submitted on time is considered invalid anymore. It's not as if it has not been submitted. And if this notice is invalid, then we all know that that means that the claim is invalid. So now we have 2 time bars in the claim procedures. Now, the next step is, okay, we call this time bar number 2. The next thing to note is that the engineer in the 2017 has, now the door is open to consider a claim that did not fulfill these time bars, these 2 that we talked about. Okay, that's one important distinction than the FIDIC 99. So the engineer, this is shown in clause 20.2.2, which talks about the notice requirement that we have seen. You see this paragraph here. It mentions that if the claiming party receives a notice from the engineer that you're late in your submission of the notice and therefore it's time barred. But then here, if that party has says that there are circumstances which justify this late issuance of this notice, for example, then the engineer has to consider this in the determination. Okay, and that's why we're saying it opens the door to that. By the same token, if the claiming party did not submit or was late in submitting the statement or legal or contractual legal basis of the claim, then in that case, again, the claiming party will has the opportunity, the chance to justify why this late submission, why he was late in submitting that in the fully detailed claim. And if that happens, then the engineer will take that into consideration in the determination, and this takes us to clause 20.2.5. And here is where we're going to touch on the concept of good faith. So when the FIDIC 2017 mentions that the engineer will take that into consideration, of course, is not bound to change his mind. He can apply the time bars. However, he will consider the justifications that are made, and FIDIC lists 3 possible considerations that the engineer should think about. They're not obligatory on the engineer. However, it's interesting that the FIDIC contract lists these 3 specific examples of what the engineer should consider, and they are, as you can see here on the screen, whether or to what extent the other party would be prejudiced by acceptance of this late submission. The second one is in the case of the late notice for the claim. The engineer, if will consider any evidence that suggests that the other party had prior knowledge of the claim, okay, the event giving rise to the claim. Similarly, if the contractual or legal basis is late, then the engineer will consider any evidence that suggests that there's a prior knowledge of the other party of that contractual or legal base. So from those 3, the ones that really apply to good faith are those last 2. And these are definitely good faith concepts. And if I take you back to the slide that we were discussing, the signs of good faith, that would fall under this last example over here. Okay, so having prior knowledge of a claim, that is definitely, and taking that into consideration, that is definitely an act of good faith. So that's, I think, a very important example of good faith in the FIDIC 2017 contracts. Now, I've actually, completed my discussion on good faith. However, we cannot leave, because since we are already on the claims procedures of FIDIC 2017, there's an important FIDIC law concept, Egyptian civil law concept, that is actually present in this claims procedures, and that I wanted to highlight. That can be as well a 5th topic from the 4 topics that we're discussing today. And this, if we go back to the slide and here about 20.2.5, we've touched on the last 2. But what about the first one? If you read the first one, it says whether or to what extent the other party would be prejudiced by acceptance of the late submission. Now, let's think about this a bit. What this is saying is that, say that the claiming party, we can no longer say contractor anymore, the claiming party is late in the notice requirement. As we know from the 99 contract, then the time bar applies immediately, right? Ala tool. So as the contractor is time barred contractually. And also by the FIDIC 2017, if the contractual legal base is late, then there's no notice submitted, therefore claim is invalid. So what this is saying, okay, put this aside now, put those contractual requirements aside, and let's see how this late submission really affected or prejudiced this other party. Did it really affect them or not? So this really touches on the concept, it is suggested it touches on the concept of harm in the Egyptian Civil Code. So for example, if we see this Article 5 in the Egyptian Civil Code, which is a mandatory article. So this talks about the unlawful exercise of a right. And I'm sure this, this article is also present in the Civil Code of the UAE, in Qatar, in a lot of civil code jurisdictions in the MENA region. And so if you look at, it says the exercise of a right is considered unlawful in the following cases. If you look at the first case, if the sole aim thereof is to harm another person, and then B, if the benefit is, it is desired to realize is out of proportion to the harm caused. So, and in Arabic, it's the darar, repeatedly mentioned. So the emphasis here is on the darar or the harm, okay? Or in other words, how it may have prejudiced a certain person. Article 224 talks about liquidated damages. And if you notice here that, of course, liquidated damages is not applicable to what we're discussing, the claims procedures, for example. However, what I'm focusing here is that first sentence, which says damages fixed by agreement, would not be due if the debtor, the contractor in this case, establishes that the creditor, the employer, has not suffered any loss. So if there's liquidated damages in the contract, but the employer did not suffer any loss, was not prejudiced by this delay, then in that case, the damages would not be applied. So the relevance here is that the FIDIC has moved from an automatic application of the time bar, if they say, for example, the 28 days are not fulfilled, to consideration of if there's any harm or prejudice to the other party. So that's a point that the engineer should consider in the determination. And with that, I conclude this that's portion of good faith. Thank you very much.
Thank you, Dr. Waly. This was very interesting because under the FIDIC 99, we were trying to work around the time bar provisions if the contractor fails to submit a notice of claim within the required time scales. In an attempt to do that, we used to resort to the concepts of good faith and to Article 5 of the Egyptian Civil Code. But it seems that the FIDIC 2017 made it much easier for the contractor to do so. Let's take this poll question. Do you support FIDIC's inclusion of these good faith provisions in the 2017 edition? Okay. Sounds interesting that the majority support FIDIC's inclusion of these good faith provisions in the 2017 edition. It seems that we have many contractors here, people working with contractors on the contractor side in this webinar. Okay. Okay, we'll take another poll question. There are those who think that the time bars under the FIDIC 2017 claims procedures are an improvement from the time bar in the FIDIC 99 edition, while there are those who disagree. Hence, this poll question attempts to get feedback as to whether these FIDIC additions are welcomed by the participants. Okay. It seems that the majority think that the time bars under the FIDIC 2017 claim procedures are an improvement from the time bar in the FIDIC 99 edition. Okay. Okay. Dr. Waly, could you please touch upon force majeure and its relevance to the FIDIC 2017?
Yes, thank you, Dr. Salwa. But actually, before talking about this concept, I would like to emphasize on the importance of the time bar provisions and improvement in 2017, because actually in several arbitration proceedings, we witnessed that problem when contractors submitted their claims and engineers did not accept the claim or did not make a determination based on the elapse of the notice period. However, in arbitration, the employer is faced with the good faith principle, which led that arbitrators will accept these claims. So this is now actually a very important improvement, and I think this will give the engineers or will open the doors, as Dr. Walid mentioned, for engineers in order to apply the good faith or husn al-niyya concept in order to accept the contractor's claim on that basis. So I think this is a very important concept. Now I will start the second concept that we will discuss today, which is the force majeure in 1999 and the exceptional events in 2017. And I think this is also a very hot topic these days because of the COVID-19, and I hope that all participants are well and safe, and that everyone did not have any problem with this pandemic. So as you all know, before talking about actually the FIDIC 1999 or the force majeure or the 2017, I would like to present these concepts in the Egyptian Civil Code. So first I will start with the concept of exceptional events in the Egyptian Civil Code, الحوادث نظرية الظروف الطارئة, Article 147. As we all know, this is a mandatory rule. العقد شريعة المتعاقدين. The contract makes the law of the parties. However, in the second paragraph, there is an exception when, however, as a result of exceptional and unpredictable events of a general character, the performance of the contractual obligation without becoming impossible becomes excessively onerous. So it is not an impossible obligation. However, it becomes onerous in such way as to threaten the debtor with an excessive loss. The judge may, according to the circumstances and after taking into consideration the interest of both parties, reduce to reasonable limits the obligation that has become excessive. So this is the Article 147 of the Egyptian Civil Code that is presenting the exceptional event or نظرية الظروف الطارئة. And probably, as you all know, it is also presented in Article 658 in عقد المقاولة, in the clauses of عقد المقاولة, almost the same clause. This is a part of Sanhuri's book. Sanhuri, when he was explaining this principle, the principle of exceptional event, one of the condition is that the exceptional event should be general and should be exceptional. And then Sanhuri gave some examples such as earthquake, wars, and so on. And as you can see, what is underlined here, or وباء ينتشر, so he is referring to pandemic. Definitely these examples are not in the law. These are just some examples in Sanhuri's book. So Sanhuri has referred to the وباء or the COVID or any pandemic as an exceptional event. So if we go back and analyze Article 147, we will find that the law requires some conditions in order to apply this concept. The first one is that the event should be exceptional and general. So it should be حادثة استثنائية and عامة. It also could not have been expected. لم يكن في الوسع توقعها عند التعاقد. So it could not have been expected when entering into the contract. So these are two main conditions. And the third one is that the contractual obligation, although it is not impossible, but exhausting to the debtor and threaten him of exorbitant loss. So this is the third condition to apply the نظرية الظروف الطارئة. The consequence is that the judge may, after taking into consideration the circumstances and weighing the interest of the two parties, will reduce the exhausting obligation to a reasonable margin. So this is the consequences in case an exceptional event will occur. Now let's go and see how the force majeure clauses are presented in the Egyptian law. And as you know, or here I'm also presenting a part of Sanhouri's book. When he was explaining the exceptional event, he said that the fourth condition, as I said, أن تجعل هذه الحوادث تنفيذ الالتزام مرهقا لا مستحيلا. So the contractor obligation is not impossible, but it is difficult. And he said that here, this is the difference between the exceptional event and the force majeure. So they are both impossible to predict and it is impossible to prevent. However, the main difference is that in the force majeure, the contractor obligation will become impossible. However, in the exceptional event, the obligation will become onerous, as we said. So this is actually the main difference between a force majeure and an exceptional event according to the Egyptian law. Again, if we analyze what Sanhouri said, we will find that the conditions to apply the force majeure clause is that the event is exceptional and general, exactly as the exceptional event. The force majeure could not have been expected during the tendering or during signing the contract, exactly as the exceptional event. However, the main difference is in the contractual obligation. In the force majeure, the contractual obligation becomes impossible to perform. However, in the exceptional event, the contractual obligation is not impossible to inform, but is onerous and will threaten the debtor of excessive loss. So if we go to the consequences of the force majeure, this is clear in Article 159 of the Egyptian Civil Code, as it stipulates when an obligation arising out of a bilateral contract is extinguished by reason of impossibility of performance, correlative obligations are also extinguished and the contract is rescinded ipso facto. So العقد يفسخ من تلقاء نفسه في حالة استحالة التنفيذ. So in case of a force majeure, according to the Egyptian civil law, the contractual obligations will become impossible to perform and the contract is rescinded ipso facto. So after presenting the Egyptian law concept and the difference between the force majeure and the exceptional event, let's go back to the FIDIC and see what are the differences between the FIDIC 1999 and the 2017. In the FIDIC 1999, clause number 19 was covering the force majeure concept, and in 1991, the FIDIC was defining the force majeure as an exceptional event or circumstance, and then it gave 4 different conditions. The first one, it is beyond a party's control. Such party could not reasonably have provided against before entering into the contract, which having arisen such party could not reasonably have avoided or overcome, and which is not substantially attributable to the other party. So this is exactly the same conditions as per the Egyptian Civil Code. And the last paragraph says that force majeure, I'm sorry. Sorry, there is something in my screen. Force majeure may include Dr. Walid, can you help me with that? Because I think I went...
Yeah, the last sentence says force majeure may include, but is not limited to, exceptional events or circumstances of the kind listed below, so long as conditions A to D are satisfied.
Oh, okay, yeah, thank you. Okay, so this is the force majeure clause in 1999. And now in the exceptional event in clause 18 in the 2017 FIDIC, you will find that exceptional events means an event or circumstance which is beyond the party's control. The party could not reasonably have provided against before entering into the contract. Having arisen, such party could not reasonably have avoided or overcome, and is not substantially attributable to the other party. So it is exactly the same definition as the force majeure. And also the last sentence is also exactly the same. So the FIDIC has only changed the definition or the term force majeure to exceptional event. So the last sentence also read as follows: an exceptional event may arise but is not limited to any of the following event, may comprise but is not limited to any of the following events or circumstances, provided that conditions 1 to 4 above are satisfied. So it is exactly the same definition as the force majeure of the 1999. Now, if we go to the notice, in the 1999, the notice of force majeure, if a party is or will be prevented from performing any of its obligations under the contract by force majeure, then it shall give notice to the other party and so on. So the FIDIC is now saying that the performance is or will be prevented. The party is or will be prevented from performing any of his obligation based on the force majeure. In 2017, again, it's exactly the same wording, the notice of an exceptional event, if a party is or will be prevented from performing any obligation. So it's exactly the same wording. However, it is very important to clarify why, from my point of view, the FIDIC has changed the term from force majeure to exceptional event, because this is actually the term used in the civil law jurisdictions. It's used in the Egyptian civil code, in the UAE and Qatari and all many of the Arabic countries. We are using the term exceptional event, which is, I believe, is more general. That's why the FIDIC has selected to also use the terms that the civil law jurisdiction is using. So if we go to the components of the exceptional event clause of the FIDIC 2017, we will find that the exceptional event is beyond party's control, is not substantially attributable to the other party, and could not reasonably have provided against before entering into the contract. Any party is or will be prevented from performing any of its obligation under the contract. According to the 2017 and according to the 1999 also, there is a duty to mitigate on the party who will face such exceptional event. And the consequences, according to the 2017 FIDIC, is that the contractor, in case he suffers delay and or incurs cost by reason of exceptional event, then the contractor will be entitled to extension of time and will also be entitled to cost unless the exceptional event is due to a natural catastrophic, such as an earthquake, volcano, and so on. Also, each party will have an optional right to terminate the contract. However, in case this right will be in case of the elapse of 84 days of continuous delay, or the elapse of 140 days of non-continuous delay, but for the same event. Now, it is very important to clarify that when the FIDIC say prevented from performing the obligation, this doesn't mean that this is a complete prevention or impossibility, because if it is a complete prevention, then the contractor or the party will not only suffer from delay and or cost, and there will be no extension of time and cost. So the prevention is not a complete prevention. However, the FIDIC has also covered the complete prevention in clause 80.6, the release from performance under the law. According to this clause, any event arises outside the control of the parties, including an exceptional event. So this is a more general subclause which cover any event, including the exceptional event mentioned in clause 18.1, which makes it impossible. So here we are covering the case of the impossibility, makes it impossible or unlawful for either party or both parties to fulfill their contractual obligations or under the law governing the contract. And here I added the Egyptian Civil Code Article 159, because this is a manifestation of a governing law. If the governing law is the Egyptian code that is giving the contractor the right, as you will see, the parties shall be discharged from further performance. So this is, as I said, a manifestation of the Egyptian Civil Code Article 159, which gives the parties the right, in case of impossibility to execute or to perform the obligation, to terminate the contract, or that the parties will be discharged from further performance. This is also a very revision or this amendment made in 2017 by adding the statement under the law governing the contract is very important, because it is also considering the civil law jurisdiction in this regard. Thank you, Dr. Salwa.
Thank you, Dr. Waly, for tackling this hot topic and clarifying why the FIDIC changed the term force majeure to exceptional event. Now we'll take 2 poll questions. Do you think COVID-19 is a force majeure exceptional event under the FIDIC 1999-2017 contract? And do you think COVID-19 is an exceptional event force majeure under the Egyptian Civil Code? Okay, let's stop the poll. Okay, it seems that the majority believe that COVID-19 is a force majeure exceptional event under the FIDIC 1999-2017 contract. And again, the majority believe that COVID-19 is an exceptional event force majeure under the Egyptian Civil Code. Thank you. Okay, moving to Dr. Waly. Could you please touch upon the senior liability and its relevance to FIDIC 2017?
Thank you, Dr. Salwa. Before touching on that, I just wanted to mention something about the force majeure and exceptional event that Dr. Ahmed just discussed. And on the poll question also that you had, I mean, it's an important distinction that the question is, did COVID-19 prevent performance? This is different than make it more difficult or making it have more time. So this is the key question here. So in terms of FIDIC, did it prevent? I mean, if you were taking on these safety measures and precautions and you're moving slowly with the work, the lower productivity, that's not prevention. It did not stop, did not prevent the work. In the civil code, exceptional event, did it make the work more onerous? And this is something that can be subject to discussion. Another point that I wanted to raise, as Dr. Ahmed explained, all the FIDIC did from 1999 to 2017 is they changed the terminology from force majeure to exceptional event, and with that, it's almost tailored to the term that we as in the MENA region, civil law jurisdictions, the term that we're used to. Actually, not just the MENA region. I mean, the concept of hardship is also in other civil law jurisdictions as well, European, and so on and so forth. However, there's an important distinction, and this is still a difference between the civil law and FIDIC, which is in the exceptional event, the FIDIC still maintains in 2017 that it means when the work is prevented, it will be prevented. However, as Dr. Ahmed mentioned, Dr. As-Sanhouri explained that the difference between exceptional event and force majeure is one, force majeure makes the work impossible, whereas exceptional event makes it just onerous. So the distinction here is that in exceptional event, the FIDIC did not refer to the work being onerous. It still maintained that it's still prevention, which is still, this is an important distinction between both the Egyptian Civil Code and FIDIC. Now, of course, again, we cannot talk about the Egyptian Civil Code and the Civil Code of a lot of MENA region countries without talking about decennial liability. Okay, so the question here is, did the FIDIC take into account the decennial liability in any way, shape, or form? And the closest clause that we could find that touches on that, which Dr. Ahmed briefly touched on in the beginning of this presentation, is Article 651 of the Egyptian Civil Code, which holds the architect and the contractor jointly and severally responsible for a period of 10 years if a partial or total collapse or demolition happens, tahaddum kulli or juz'i. So you have the 10-year period here, and you have this joint responsibility. And so this is what the Civil Code mentions, which is, of course, mentioned in a lot of other civil codes as well. And if you look at this clause, this is from the FIDIC 1999, you had this clause called unfulfilled obligations. And if you read it, it just mentions that after the performance certificate is issued, each party shall remain liable for the fulfillment of any obligation which remains unperformed at that time. And for the purpose of determining this nature and the extent of the unperformed obligations, the contract shall be deemed to remain in force. The thing that is notable here is there's no time period at all. So it's unfulfilled obligations to eternity. So there's no time period until when is it liable. Of course, one might say, well, the FIDIC in clause 1.4 says that the law to govern is, that of the country. But in 2017, they made it more. They have another paragraph added to 11.10. This second paragraph, and it mentions here that in relation to plant. So plant is the machinery or equipment and apparatus that is used. The contractor shall not be liable for any defects or damage occurring more than 2 years after the expiry of the defects notification period. So you have the DNP, and then you have 2 years. And with that, the FIDIC made a cap of the contractor's liability. But then the notable thing here, it says, except if prohibited by law. So it's almost like FIDIC is saying, okay, so we will seize the liability of the contractor after 2 years for plant, after the 2 years of the DNP. However, it seems like they realize that but civil law jurisdictions have this 10-year period, so maybe we should insert this so that we're not conflicting, the 2 years is not conflicting with the 10-year period, for example. And further proof of that, actually, you can see it in the guidance. The guidance for the preparation of the particular conditions in 2017, it has this excerpt, and it mentions clearly that it may be necessary to review the effect of this subclause in relation to the period of liability, which we believe is the decennial liability that they're talking about, imposed by the applicable law. And then in particular, regarding that second paragraph that we had touched on, it says that this subclause may require amending to take account of the applicable law. So again, it's emphasizing here, and it's confirming that they have taken into account this decennial liability, so that it doesn't, that 2 year period that is shown in that clause does not conflict with the 10-year period that is in the law. And with that, thank you very much. We've completed this at this point.
Thank you, Dr. Waly. Okay, so let's see this poll question. Do you think that the unfulfilled provisions in the FIDIC 2017 contract is sufficient to address the decennial liability in the Egyptian Civil Code?
So just to clarify also by this question, is it, do you think that FIDIC should have inserted more words, for example, to cater to the 10-year liability period, for example, or are those words, this paragraph that we've seen, is that enough? Is that sufficient or not?
Okay, it seems that 50%, exactly 50% agree or believe that the unfulfilled obligations are sufficient to address the decennial liability, and 49% believe that they're not sufficient. Okay. Moving on to Dr. Waly, could you please elaborate on the termination for default and its relevance to FIDIC 2017?
Yes, thank you, Dr. Salwa. Again, the FIDIC once again has added a new subclause, the contract termination, subclause 1.16. In subclause 1.16, this is a totally new clause in 2017 that was not in the FIDIC 1999. And this clause reads as follows: subject to any mandatory requirements under the governing law of the contract, termination of the contract under any subclause. So whether we are talking about termination for convenience, termination for default, any termination of these conditions shall require no action of whatsoever kind by either party other than as stated in the subclause. As you know that in the 1999 and in the 2017 different termination for default clauses, it was written that, for example, if the contractor is in default, then the employer shall send a notice, for example, or shall serve a notice and so on. But it never mentioned that we need to go to, we need to serve a court summon or a court order. And as you probably know that in Article 158, which is covering the termination for default clause, article is saying the parties may agree that in case of non-performance of the obligation flowing from the contract will be deemed to have been rescinded ipso facto without a court order. Such an agreement does not release the parties from the obligation of serving a formal summon unless parties expressly agree that such a summon will be dispensed with. So according to this article, the party, in order to terminate the contract, he has to serve a formal summon, and to get a court award, unless the parties agreed expressly in their contract that this is not required. So now the FIDIC has expressly revised its the 1999 by adding in the 2017 this article or this subclause to expressly say that the parties are not required to do anything except what is written in the termination clauses. So now it is clear that the parties are not required to go to the court or to serve a summons. So this will cover the article or the requirement of the Article 158.
Great, thank you, Dr. Waly, for this clarification. It seems that was not that there is a great transition in tackling the, especially the determination clauses under the FIDIC 99, when interpreted in the context of the civil law, we had to make to make some amendments in the particular conditions.
Yeah.
Okay, by this we conclude the panel discussions part. Sounds very good food for thought regarding the influence of the civil law jurisdictions on the FIDIC 2017 edition. Now the floor is open for questions. We will take your questions from the Q&A section. I remind you that due to the expected large number of questions we have, we might not be able to answer them all. We've opened the voting, and we will start by the question with the largest numbers of votes, which will appear at the top. Okay, so we'll take the first question. Will you please share the presentation file at the end? I believe that we will share with you the presentation file. Okay. What is the difference between the force majeure in its effect and the frustration of the contract? Okay, I'll direct this question, Dr. Waly. The difference between the force majeure and the frustration of contract.
Okay. Thank you, Dr. Salwa. The frustration of contract is a common law concept, and we cannot compare the force majeure to the frustration. Frustration is similar to the exceptional event. The frustration will make the contract more onerous. It will threaten the contractor or the employer by excessive loss. However, the obligation will not be impossible. So the force majeure will make the obligation impossible to perform. However, the frustration or the exceptional event will make it onerous to perform. So this is the main difference. So the difference is mainly in in this condition. However, they are both unpredictable and exceptional and so on. I don't know if Dr. Walid would like to comment also on this issue.
I agree with you. I have no further comments.
I do agree with you. Okay, a question to Dr. Walid. Sometimes the employer requests the contractor to proceed with change orders while the time and cost impact are still under negotiation. How could this situation be managed? This may lead later to disputes if no agreement is reached.
Yes, well, I think this, as soon as, the key point here is if this item, this change is agreed, at least between the parties, the engineer and the contractor, that this in principle has merit. So if this has merit, it's an acknowledged change and the contractor proceeds with that change, then what we do in practice is we issue, the engineer issues something called the change notice or a variation instruction to acknowledge that this is a variation. And in the same time, this is a cue for the contractor to submit in the first payment application and the next invoice to submit these works for payment. And the engineer must at least process an on-account payment for this amount. So the contractor is working and is getting paid for this change per the engineer's assessment. And of course, the engineer's assessment will be made accurate and can reach an agreement with the contractor when proper substantiation or full substantiation is provided. So it would be good practice if the contractor submits the detailed particulars of that change as soon as possible, because as you know, in practice, what happens is the contractor submits a notice and the contractor then submits detailed particulars later on. Maybe the time is the one that takes a long time, but the cost should be submitted promptly and with enough supporting documents. But still, that does not mean that the engineer will require the contractor to perform with no payment. Of course, the contractor must be paid in the next invoice as long as it's something that is in principle accepted according to at least the engineer's assessment.
Thank you, Dr. Walid.
Dr. Salwa, may I also comment on this question, please?
Yes, sure, please do.
Okay, because I think this is a very important question, and sometimes the employer requests the contractor to proceed with the change order. Actually, since we are talking about the FIDIC actually requires the contractor to proceed with the change order before agreeing on a time and cost. So the contractor shall proceed once he received the instruction. However, I'm sure that, or I know that many of the contractors, especially in Egypt, when working in public works, they are used to the fact that they will not start working on any change order before reaching an agreement with the employer on the time and on the cost. And they believe that the FIDIC in this issue is not fair, because they believe that the employer has the upper hand, because the contractor will start working, and then at the end the employer will have the upper hand and will be able to negotiate the time and cost. However, I would like each contractor or each participants who are thinking like that to put it the other way around. What if the employer, whenever he would like to make any changes to his project, he has to wait until the contractor agree or give him an offer and they reach an agreement on the cost and the time of this variation? Who will have the upper hand in this case? And it's very important, as Dr. Walid said in his answer, that we have to know that the engineer is the one who will make the determination, and the engineer is the fair party. In this issue, he is the fair party, and his determination will be fair. So I think that we should all agree that this is the right procedure, that the contractor has to proceed and then the engineer will make a fair determination. Thank you, Dr. Salwa.
Thank you, Dr. Wade. Okay, so the question related to force majeure, so I will direct it to Dr. Wade as well. And I think we have a number of questions related to COVID-19 and force majeure. First, we'll start with this one, not related to COVID-19, but generally to the exceptional event. I think in 2017, after changing the wording to be exceptional event, it still differs from the term under the Egyptian Civil Code, because one of the conditions of considering the event to be an exceptional event, I believe this is meant to be under the FIDIC, is to prevent the contractual obligation, which is the definition of force majeure under the Egyptian Civil Code, not the exceptional event. Am I right?
Okay, I think that's why I said in my presentation that by the word prevent, it doesn't mean a complete prevention or impossibility to perform. When you are prevented to complete your project on time, you will still be able to complete your project, but you are prevented from completing the project as per the time for completion. So that's a prevention. When you are prevented to execute the work according to the estimated cost, that's a prevention. That doesn't mean that you are prevented from performing the complete project and consequently the project should be terminated. So that's why I believe the word prevention should be correctly interpreted. It's not a complete prevention. It is just the suffer. That's why the consequences is the contractor suffering a delay or cost. So it is not that the contractor is suffering an impossibility to complete the project. And that's why in sub clause 18.6, the FIDIC is covering the part of impossibility, which is the force majeure as per the Egyptian Civil Code.
Thank you, Dr. Way. A relevant question as well. إذا فيروس الكورونا طبقا للقانون المصري ليس قوة قاهرة. إذا فيروس الكورونا طبقا للقانون المصري ليس قوة قاهرة بل ظرف طارئ. Is the COVID-19 considered exceptional event, not force majeure event under the Egyptian Civil Code?
Okay, my answer to this question is a question. Do you think that you cannot perform your obligation? If you cannot perform your obligation, then this is a force majeure and the contract will be rescinded or terminated ipso facto. If you believe that your obligation has become more onerous, then this is an exceptional event, and in this case, you should be compensated to an extent. I will also answer in Arabic. أنا في رأيي الرد على السؤال ده هيبقى بسؤال تاني. لو حضرتك شايف إن الكورونا أو كوفيد 19 منعت حضرتك من تنفيذ التزامك، بقى في استحالة في تنفيذ التزامك، يبقى ده قوة قاهرة، وبالتالي النتيجة هتكون فسخ، إن العقد هينفسخ من تلقاء نفسه. أما في حالة إن الكورونا أدت إلى مش استحالة تنفيذ ولكن الالتزام أصبح مرهق عليك، فده معناه إن دي ظروف طارئة ودي حادثة استثنائية، وفي الحالة دي المقاول هيتعوض وفقا لنظرية الظروف الطارئة. وبالتالي أنا رأيي إنه لغاية النهاردة الحمد لله إحنا شغالين، يمكن في صعوبة في الشغل ولكن المشاريع شغالة، وبالتالي وجهة نظري إن هي طبعا ظرف طارئ وليست قوة قاهرة حتى الآن، ولكن الله أعلم هيحصل إيه بكرة.
I want to, if I may, just add something. I'll also add it in Arabic. الدكتور أحمد mentioned قال إن هيتم تعويض المقاول وفقا لنظرية الظروف الطارئة وفقا للقانون المدني. لكن let's remember، خلينا نفتكر إن وفقا للقانون المدني does not say إن المقاول هيتعوض. It says إن القاضي هيعيد ممكن التوازن الاقتصادي. يعني ده خلوا بالكم إن الامبلويرز برضو اتضروا من الموضوع ده، يعني الامبلويرز برضو suffered losses. وخلي بالكم برضو ان النظريه دي it's not talking about any loss، بتتكلم على خساره يعني جسيمه، حاجه really exorbitant. طبعا الحاجه الديبيتبل في موضوع النظريه دي في القانون what is exorbitant. يعني لو واحد مقاول مثلا يعني no profit، ده مش exorbitant خالص، ده اسمها break even. لو واحد خسر بس في 5% مثلا 10%، هل ده exorbitant؟ ده برضه ده السؤال. 20-30 maybe بس يعني فتطبيق النظريه دي قانونا مش يعني مش حاجه برضه يعني فيها a lot of proof، يعني برضه حاجه مش سهله especially في موضوع كوفيد 19 برضه بالذات، ان زي ما الدكتور احمد قال الشغل شغال، مش يعني شغال جنرالي حوالين العالم، يمكن at a slower pace، يمكن حصل شويه suspensions because of bus. This is بقى لا force majeure ولا exceptional event. الحاجه اللي more relevant موضوع change of laws. مثلا القوانين مثلا بتعمل lock down، في قوانين ملزمه لازم ما فيش شغل، هنا الكليم بيتعمل على 13.7 مثلا في ال 99، مش على الفورس ماجور exceptional event. بس حبيت اوضح بس. شكرا.
طيب انا عايزه اعقب بس، يعني تكييف تاثير فيروس الكورونا طبقا للقانون المصري لازم يدرس كل حاله بعينها، يعني it should be studied on a case by case basis. There is no one answer that fits all cases. بس generally speaking زي ما قلنا ان هو غالبا مش هتبقى قوه قاهره في معظم الحالات. اوكي، ومش شرط ان احنا نفيزت بس قوه القاهره والاكسبشنال ايفنتس، يعني في other clauses in the contract that might better be tackled in such case. طيب واضح ان كوفيد 19 مؤثر جدا على الكويستشنز النهارده. Can we consider the COVID-19 a basis for claiming additional costs incurred for the safety precautions needed to proceed with the works under the variation clause?
Can I answer this question?
Go ahead.
Actually, I don't know if you all know, but FIDIC had held a series of webinars على COVID-19 in the past maybe month and a half or 2 months. One of those webinars had the same, I would say one of the FIDIC guys in the FIDIC task group and actually mentioned what I'm going to tell you is that this should be addressed as a variation to the contract. It's not a claim. It's not تحت force majeure or حاجة زي كده. This is purely a variation because the contractor is now purchasing more safety gear, protective equipment that were not anticipated at the time of signing the contract. فبالتالي this purchase of additional materials ده بمنتهى البساطة a contractor should just request a variation. يعني a variation than the equipment that is provided in the contract. To my surprise صراحة in a lot of contractors, from my experience at least, I've never seen a request for a variation on this. دايما contractors يتجهوا to COVID force majeure أو حاجة زي كده، بس the contractors should use the variations clause in this case, in my opinion.
Great. Okay. Okay, we'll take this last question. The meaning of impossibility of performance, it means that the contractor cannot perform the obligation he is liable for under the contract, meaning that he cannot complete the project within the agreed time for completion, not that he's not capable of working at all. Okay, I'll direct this question to Dr. Waly.
Actually, I like this interpretation, and actually I agree with it, that the impossibility of performance, it doesn't necessarily mean that I will not be able to work at all, but it will be impossible to complete the project on time. However, this will not lead to termination of the contract. It will lead to an extension of time maybe. So yes, it's a right interpretation of the word impossibility, and I agree with it. However, when the law in Article 159 said in case of impossibility of execution, the contract will be rescinded ipso facto, the law, I believe, meant that, meant that there is an impossibility to execute anything, so the project cannot be completed. But I like your interpretation.
If I may add something as well, I think one important factor to consider is the duration of the impossibility. So for example, if it's impossible to perform for 1 week, it's different than if it's impossible to perform for 5 months. So, and that's why in a lot of consultancy contracts, for example, you have a duration for the force majeure clause. It says if the force majeure clause takes effect for more than 6 months, for example, then the contract is terminated. But of course, and of course in the FIDIC we have the prolonged suspension, which also can result in termination. You can say it's like it has a termination effect. However, if there's an impossibility of performance or a prevention of the performance for a period of 1 week to an activity that is on the critical path of the project, then in that case, I think that the act of it's a prevention, it's an impossibility. However, as Dr. Ahmed mentions, it can lead to a time extension. Whether it's compensable or not depends on the contract, the FIDIC clause. As you know, that in the force majeure clause of the FIDIC, the circumstances of force majeure are divided into man-made factors and natural factors. So if it's a natural factors such as a flood or an earthquake, so on and so forth, then in that case, it's a time only and no cost. If it's a man-made factor, then it's cost. Of course, this touches at COVID-19 and an interesting, if you're into conspiracy theories, if COVID-19 is a bio, it's an attack, and it's something that is man-made, in that case, there would be time and cost. And if it's just a natural thing, then it's just time and no cost.
And actually, Dr. Walid, as you said, there is the optional termination clause in the FIDIC. If there is a prolonged effect of a pandemic, then a party may refer to the optional termination and may terminate. So as you said, it has to do with the duration of the effect, or how long the effect is.
Okay, I would like to thank Dr. Waly and Dr. Walid for the interesting discussion. Very good food for thought. And dear respectful ladies and gentlemen, thank you for your attention and for such interactive discussion and comments. Looking forward to seeing you in future webinars, and goodbye.
Thank you.
For moderating this webinar. It was excellent.
Yes, thank you for the excellent moderation, Dr. Salwa. Thank you very much. And thank you all for attending.
Thank you. Stay safe.
Right, take care.
باشمهندس يحيى.
شكرا دكتورة سلوى.
شكرا ليكم.
شكرا لحضرتك. معلش انا المايك عندي كان مقفول الو.
ايوه
تمام يا فندم، انا هنخرج من هنا عشان كده اعتقد ده لسه لايف.